1,000 people. My Lord, over 224,000 people were involved in the exercise, where they volunteered to give their views. And out of those, my Lord, you shall note that 65% of the people who rendered their views were in support of the motion.
Is this submission for the lifting of orders or for petition?
My Lord, I'm trying to establish the fact that heavy weather was made, my Lord, on the fact that there was no public
We have
participation.
noted those heavy weathers, but we need to be, because we are all lawyers and judges, we need to be specific to the issue before the courts. Some of the things which you say here are actually not meant for this forum. We've been trying not to intervene, but you know very well that a lot of submissions which have been made here are not for the proceedings today. They are meant for another proceeding altogether. So if you can just avoid them, the better for us.
Yes, my Lord, I stand guided. And then that...
In other words, Mr. Milimo, you may spare us the submission on the sufficiency of the public participation.
Correct, my Lord. Yes, my Lord, I stand guided, and I was just going, my Lord, to refer you to one authority that we had, my Lord, attached as authority number 1 in the supplementary list of authorities. If you are to look at page 4 of that authority, my Lord, the sufficiency or otherwise of public participation exercise, my Lord, is to be determined at the main trial. And my Lord, therefore, I would agree with you that all I need to do, my Lord, is to refer you to the report that I've indicated, my Lord, that it appears at page 427, specifically the findings, my Lord, to 455 of the replying affidavit. But, my Lord, allow me just to pick one thing out of that report. You are particularly, my Lord, referred to one of the constituencies, specifically, my Lord, Keio South constituency, where my learned colleagues, my Lord, raised issues that indeed the figures did not tally. My Lord, first, you shall note that the figures that were quoted by the petitioners, my Lord, are contained nowhere in the public participation report that have been submitted before you. My Lord, I want to believe that my learned colleagues got that information from sources other than the report that was submitted at the National Assembly. My Lord, Keio South views, my Lord, are submitted to be found firstly at page 289 of the report, my Lord, and it appears as item number 95. And this goes specifically, my Lord, to the hand-delivered and email views, where it was indicated that, my Lord, there was a total of 465 responses, and out of those, my Lord, 455 were in support. That is what, my Lord, is contained in the report as the first limb. The second limb, my Lord, is for those who participated in the public hearings of the 4th, my Lord, of October, and is found at page 331. Same Keio South constituency. And, my Lord, it's indicated that a total of 355 people did, my Lord, attend that public hearing. And out of those, 352 persons, my Lord, supported the motion. Lastly, on that point, my Lord, is to refer you to page 440 of the replying affidavit, my Lord, where you shall note, not 440, my Lord, I'm sorry, page 439, where, my Lord, you shall note that the total responses in respect of Keio South constituency were 820. And that out of those, my Lord, in support were 807. So, my Lord, the views are submitted, or the submissions are submitted by my Lord colleagues, my Lord, do not find any favor in the report. And therefore, my Lord, I'll urge you that you do ignore them. My Lord, I also need to point out that public participation, my Lord, is not a referendum. As well understood, my Lord. And that in the words, my Lord, of your learned brother, justices and sisters, my Lord, in the affordable housing decision, public participation does not, my Lord, necessarily mean that everyone in the country must give their opinions. My Lord, that is paragraph 175 of the affordable housing decision. And that, my Lord, all that the National Assembly was required to do at paragraph 176 is to give the public an opportunity, my Lord, to submit their views. And my Lord, you shall note that in the report, all that was done by the National Assembly. And therefore, in the fullness of time, my Lord, we shall demonstrate before you that there's absolutely no arguable point, and the public participation exercise that was conducted, my Lord, by the National Assembly was not only meaningful, but was sufficient both qualitatively and quantitatively. My Lord, the other issue that was raised was by my learned colleague, Mr. Omari, on public participation, where he indicated, my Lord, that elections are conducted at the polling stations. My Lord, that submission is not true. The presidential, my Lord, elections are provided for in terms of being conducted, my Lord, at Article 138.2, where it states, my Lord, that the elections are at the constituency level and not at the polling station. My Lord, the other issue that arose from the submissions from my Iranian colleagues is whether, my Lord, the first petitioner was given an opportunity to present his reply to the public prior to the public participation. My Lord, my answer to that is simple. That first, my Lord, the public participation exercise commenced on 2nd of October all the way to 5th. And my Lord, by the time the public participation commenced, the first petitioner had not submitted his response or lodged his response to the National Assembly. And therefore, there's no way, my Lord, that that response could have been availed to the public. Secondly, that, my Lord, the National Assembly only avails what is in its possession. And therefore, at that point, my Lord, the National Assembly could not have been accused of not, my Lord, presenting to the public what had not presented to it. But more important, my Lord, there is no legal requirement, and none was cited by our learned colleague, that dictates that the National Assembly had a duty to present, my Lord, that response to the public during public participation. And last, my Lord, nothing stopped the first petitioner, my Lord, from himself presenting that response to the public, as he did, my Lord, on the eve of the hearing or proceedings at the National Assembly. The last point, my Lord, on public participation was whether, my Lord, the Senate ought to have conducted the public participation exercise. And, my Lord, my answer to that is this, that under Article 118B, my Lord, of the Constitution, Parliament is, yes, required to conduct public participation. But, my Lord, Parliament under Article 93.1 refers to both the Senate and the National Assembly. And, my Lord, you shall note that the impeachment proceedings are two-tier. That the first stage, my Lord, is conducted by the National Assembly, and the second one, the trial chamber, is the Senate. The Senate sits as a quasi-judicial organ, my Lord, in respect of the impeachment proceedings, and that it's not required to repeat the public participation exercise. Because if that were to be so, my Lord, then it means that even this court sitting in exercise of the judicial function, it could be required, my Lord, to undertake the public participation exercise.
Mr. Melema, we only entertained you on these submissions because we had entertained other people earlier. That is the only reason we are listening to you.
I thank you, my Lord. But I'm winding up on that, my Lord. Yes. My Lord, the second issue that, my Lord, I'll invite your attention to is on the subject, my Lord, of fair hearing. My Lord, under that limp, there was a challenge, my Lord, to the standing orders of the National Assembly. My Lord, my answer to that is simple, that there is a presumption of constitutionality of those standing orders, my Lord, and that at this stage, being an intellectual stage, this court, my Lord, has no power to invalidate those standing orders, my Lord. In the fullness of time during, my Lord, the main hearing, we shall demonstrate to you that those standing orders, my Lord, reflect Article 145 and 150 of the Constitution, and that their simple duty, my Lord, is to implement those articles of the Constitution. The other issue, my Lord, that was raised was about impartiality of the Speaker of the National Assembly, my Lord. Yes, and my Lord, you shall note that the Speaker of the National Assembly, my Lord, has no vote in the proceedings, and that is, my Lord, under Article 122(2)(a) of the Constitution, and that submission, therefore, my Lord, is not a valid submission. And my Lord, more importantly, my Lord, you shall note also that at the National Assembly, the first petitioner was given an opportunity to both appear and be heard. And my Lord, he did file a substantive response to the notice of motion. And more importantly, my Lord, he was given 2 hours to present oral representations. That opportunity he took, my Lord. And therefore, the question of there having, my Lord, been a breach on the elements of fair hearing does not arise whatsoever or at all. My Lord, my last point is on the nomination, my Lord, of my good teacher, Professor Kindiki. And my Lord, the issue was whether there ought to have been, my Lord, an approval process at the National Assembly, and whether, my Lord, there ought to have been public participation, as well as, my Lord, the timelines that were invoked, my Lord, to process the good professor. Yes, my Lord, all I need, my Lord, to bring to your attention is there was a ruling, my Lord, by the Speaker of the National Assembly that we attached to the first respondent supplemental list and band of authorities, dated, my Lord, the 28th of October this year. And my Lord, you shall note that in that communication, the Speaker did address all those issues, my Lord. The communication, my Lord, is communication number 54 of 2024, and it's dated the 18th October 2024, where, my Lord, the Speaker did address in giving guidance to the House all those issues, and I will invite you, my Lord, to refer to it when you retire. My colleague, Mr. Macharia, my Lord, on a light note, told the court that, my Lord, I would have said Weta Tosha. My Lord, I'll say that in 2032 when the right comes. I thank you, my Lord, unless your Lordship have any questions.
My Lords and my Lady, I'll proceed from where my learned friend Mr. Milima stopped. Permit me, for completeness of record, to say that the second respondent has filed an application dated the 18th of October 2022. We have filed submissions in support of that application, again dated the 18th of October 2022. And we have a replying affidavit sworn by one Samuel Jeroge on the 21st of October 2024. My Lords, we also have submissions in response to the application seeking conservatory orders dated the 27th of October 2024. And finally, the list and Digest Authorities dated 27th of October 2024. I'm reminded by my colleagues that I forgot to mention my name for completeness of record. My name is Eric Gumbo. That said, I would want to start by bringing all of us to the same pedestal in understanding the application and the prayers that are currently live before the court. Permit me to draw your attention to the application filed by our learned colleagues in the matter 565 for 2024 for just one purpose only. The application has a total of about 13 prayers. The prayer number 1 all the way to prayer number 10 have been spent. In other words, they've been overtaken by events. The last prayer, which perhaps would have been relevant for purpose of understanding what I'm trying to get to, is prayer number 9, which talks about that pending the hearing and determination of a petition, a conservatory order restraining the National Assembly of Kenya from discussing, vetting, voting, and or approving the nomination of a person submitted to the National Assembly made on the 18th of October 2024 by the President of the Republic of Kenya, His Excellency William Samoei Ruto, to fill the vacancy of the office of the Deputy President of the Republic of Kenya. That prayer is equally overtaken by events. The last prayer is for deletion of what they call falsehoods to various persons and institutions. It then follows, my lords and my lady, that the petitioner, His Excellency Rigathi Gachagua, has no prayer that is live before you in relation to the question of conservatory order. Looking at the application number E015, the only prayer that is live before you is prayer number C and prayer number E, both of which deal with the question of swearing in of the second interested party appointed by the President and approved by the National Assembly, they say, from assuming the office of the Deputy President. It then is our submission that the threshold question, the arguability question, the negatory question needs to then address the issue of swearing in. I will then straight go to the issue of swearing in. My lords and my lady, we've spoken to the provisions of Article 145.7. 145.7 very clearly indicates that if at least 2/3 of the members of a Senate vote to uphold any impeachment charge, the President shall cease to hold office. May I add to the submissions that have been made previously that that provision is a self-executing provision. You do not need more. It is not an action of the Senate, it is an action of the Constitution itself. The first question that then we would want to ask ourselves this afternoon is, in light of view of such an express provision of the Constitution, is it tenable that an order of this court would issue to stop it? Let me take as one step further to remind us that at the point at which the Deputy President was impeached, he then acquired a constitutional blemish. And we say a constitutional blemish because under the provisions of Article 150, all the charges that were substantiated as against him, including the question of gross violation of the provisions of this Constitution, serious reasons to believe that the deputy president committed a crime under the national or international law and gross misconduct, then were issues that would be said to have informed his constitutional standing. Now, where am I going with that? I'm trying to make the point that